Good morning and welcome to the First District Court of Appeals. We have 3 cases to be argued this morning. When I say the name of your case, please state your name and your readiness to proceed. State v. Henderson.
Good morning, Your Honor. Sarah Nelson on behalf of Anthony Henderson.
Good morning, Your Honor. John Hill on behalf of the State of Ohio. Ready?
Thank you. Next we have State v. White.
Sarah Nelson on behalf of J.B. White.
Bill Cummings for the state. You may proceed.
Okay, thank you. And then finally we have State v. Smith.
Good morning, Michelle Berry on behalf of Kent Smith.
Morning, Your Honor. Steve Sutton for the state.
Okay, thank you. I will be using the light system. When you see the yellow light, that means you have about a minute left. And whenever you're ready, counsel, coming up, would you like to reserve any time?
Yes, Your Honor. 3 minutes for rebuttal, please.
Okay, thank you.
Good morning again, and may it please the court. Good morning, opposing counsel. Sarah Nelson again on behalf of the appellant Anthony Henderson. And per the court's recent entry, I'd like to begin this morning by addressing the question of mootness. Presumably that a question arises because of the court's entry terminating probation upon Mr. Henderson having paid the restitution. And despite that payment of restitution and the termination of probation, it's our position that this case is not moot, and for 2 reasons. One, the entry terminating probation doesn't clearly terminate the outstanding fine, which is still viable in this case despite our assignment of error number 3, asking this court to vacate that fine. It's still in the sentencing entry, and it's our position that it's still at play. Having done a number of expungements in this county, sometimes lingering fines without clear record of them being mitigated, hold up an applicant for expungement purposes. And with that in mind, and without the record being crystal clear on what happened to that fine, I would take the position that the fine is still at play. Even if it's not, I think this is a clear case of when an appellant does not voluntarily serve their sentence. So I have been reversed by this court on mootness before, where my client had paid a fine despite being granted a stay of execution pending appeal. But that's not exactly what happened in this case. Mr. Henderson was granted a conditional stay. The stay would only be in effect if he went through the process to have an EMU monitoring device during the process, the pending appeal, which never was invoked in this case.
So doesn't that kind of like cut against you because it appears as if it actually was not stayed?
I disagree. I think what it suggests is that the stay was never invoked, which means it was in practice denied. So hypothetically, if it had been a monetary bond that he could not pay, then he would be incarcerated. The stay would not go into effect. That's the analogy that I think is more appropriate here. If there's any confusion as to whether or not there's a voluntariness aspect, I would point the court to the trial court's entry terminating probation, where it says that the defendant paid restitution as instructed per phone conversation with your honor to terminate on 9/11, which to me suggests that there was some ex parte communication between the client and the judge directing him to pay restitution. We know from the sentencing transcripts that the judge was very insistent on restitution being paid. She wanted him to hand it over at the sentencing hearing. Our defense counsel very adamantly said, no, he's not going to do that. We're asking for a stay pending appeal. I'm not sure what the substance of that conversation.
And he handed it over during the restitution hearing based on the assertion of the bench saying that none of the fines and costs would be invoked, then wouldn't it be moot at that point?
I don't believe that the sentencing transcripts reflect.
Not that it matters for this purposes, but it seems as if perhaps things were being queued up for mootness if the restitution had been brought to the sentencing hearing.
Yes, I would agree with that characterization, and I think defense counsel was trying to protect his right to appeal by asking for a stay, avoiding that situation by the immediate payment, and the stay was granted conditionally. So back to my previous argument, because it wasn't invoked, because it doesn't appear that he paid it right at that sentencing hearing and it was turned over to probation, this isn't a case where he voluntarily paid the restitution and terminated probation on a voluntary basis. He definitely intended to protect his right to appeal.
And although it doesn't go to mootness necessarily because of the facts in front of us, What was the pronouncement in court with regard to fines and costs? What is your position on that?
I believe the record says 150 in costs, which this court recently sort of addressed a similar situation in State v. Robinson, where the use of the word in the transcripts, that's what we have to rely on as to what was pronounced in open court.
Have you listened to the actual audio recording?
No, Your Honor. I only ever request the
I understand.
transcripts.
Okay. And the reason is because costs are not $150.
Agreed, yeah. So it's an improper fine.
So it makes me question whether it was $150 and costs.
Yeah, there could be a typographical error for sure, which I think is what may have motivated this court's decision in Robinson to reverse and remand for clarification on what the court intended. Personally, I would ask this court to vacate the fine, but recognizing the recent precedent from this court, reverse and remand to figure out honestly what happened with that fine. Is it still at play? Did the court intend to mitigate it when it terminated probation? Are still things that are available remedies for my clients?
Well, but if we did that, the court might remit the fines and cost, and then it would be moot, right? If we remanded it to clarify and the court put on entry remitting the fines and cost, that would take away some of your argument.
If this court only remanded it, did a limited remand, then yes, it would moot out the merits of the appeal. But again, for the reasons I cited earlier, this isn't a voluntary service of the sentence. So even if that occurred, I still think that there's actions taken by my client and defense counsel to protect his right to appeal, to ask for that stay. Which brings me to the merits of this case. I think at any rate, this court should consider the merits of this because Defense Exhibit C, in our view, is a clear indication that a payment was made for the merchandise in question. And in light of Defense Exhibit C, the screenshot of the bank statement, the state has not proven beyond a reasonable doubt that he purposely deprived the Jewelry Palace of its merchandise. Defense Exhibit Z negates essential elements of the offense, which puts this squarely before the court as a sufficiency issue. We construe all the evidence in favor of the state, and I don't think there's any getting around the fact that Defense Exhibit C clearly shows a line item with a purchase date of 3/26 and a settlement date of 3/27 in the amount of $140 at the Jewelry Palace. That's a significant fact before the trial court that disproves an essential element of the offense.
Was there consent at the time that he obtained the jewelry? Was there consent by the vendor at the time that your client obtained the jewelry?
Interesting question. I would say yes, because the officer allowed my client to leave the store with the merchandise, and the shop owner was aware that that was happening. The shop owner took my client's information, knowing that he was going to leave the store with the merchandise, even though there was this conflict apparently between the two parties as to whether or not something had been paid. My client was allowed to leave the store with the merchandise. So something he showed to the officer, his phone, not something, we know that he showed the officer the notifications that popped up on his phone saying that Chime Bank had registered the $140 payment and immediately rejected the subsequent charge because he had insufficient funds. The officer was aware of this, let my client leave the store, provided his information to the shop owner, but again was allowed to leave the store with the merchandise. So yes, I believe that that goes to the issue of consent. He didn't deprive the property owner without consent of the parties allowing him to leave. But again, I think that
It seems that lack of consent would be quite opposite to the facts, since there was an officer on site,
Yep,
and the owner was on site,
correct, agreed.
and there was a conversation, and then your client walked away with the jewelry, quite known to both the officer and the vendor.
Yes, and having represented to everybody at the scene that his bank had notified him that the purchase had gone through. And he showed the court a screenshot of his bank statement that reflected that payment. His screenshots are consistent with this, the bank statement screenshot is consistent with the screenshots from his phone with those notifications. You'll notice from Defense Exhibit A and B, there's also a Metro Petrol notification for $2. That's also reflected in Defense Exhibit C. So to the extent that the trial court found that Exhibits A and B, the screenshots of the phone notifications, were inconsistent, that really boils down to other notifications from other companies, not the bank statement, which is Defense Exhibit C.
But doesn't that then require us to start weighing evidence if we're going to start looking at the actual evidence and interpreting it? Aren't we then becoming sort of triers of fact
Yes.
Which is even beyond your assignment of manifest weight.
I did argue a manifest weight assignment, a second issue under my first assignment of error was sufficiency and manifest weight.
Correct.
I will pause to
But
say that.
it seems that looking at the evidence and interpreting it and so on goes beyond our mandates under manifest weight. Do you understand what I'm saying?
Yes,
And it's okay if you don't.
Yeah, I'll just repeat what I think you're saying, is that the
Okay.
court doesn't necessarily want to become a trier of fact, but it does get to look at all of the evidence and determine if the more credible evidence outweighs the evidence that was presented at trial. That's what this court does get to do as, on a manifest weight standard. It does get to not necessarily reweigh the evidence, but consider it all not with any deference to the state, which is what sufficiency requires. Again, I would say that Defense Exhibit C, even construing all the evidence in favor of the state, survives a sufficiency review because it disproves an element of the offense. But even if we're getting to comparing
And which is the
exhibits,
element that you would say it disproves?
deprivation, depriving the store owner of its merchandise. It didn't do that. It paid for the merchandise in that Exhibit
But
C.
doesn't that again bring us back, which is a little different than what consent would give you?
Correct. Mhm. Yes.
Do you understand what I'm
Yes,
saying?
I do understand. I just respectfully thought that I specifically purposely deprived the shop owner in my sufficiency analysis, although I do take your point because it was argued in my brief in terms of the purpose to deprive aspect, the officer's exchange with my client and letting him leave the store. So that does go to consent. I'm just having to rework my memorization of my brief.
It's okay.
Turning, though, to the weighing of the evidence, because I think that that's the standard of review on sufficiency is whether any reasonable minds could find in favor of the state. And I don't think reasonable minds can conclude that my client deprived the store of anything when you look at Exhibit C and you see that line item that says $140 paid to the Jewelry Palace. That's my argument with respect to sufficiency. But if we're arguing about the credibility of that evidence, then I still think we win on a manifest weight review because the state's evidence, the PNC bank records, don't disprove that payment. So the shop owner produced that one receipt from 2 p.m. on the day of the incident, but the line item in the banking records doesn't reflect that. It doesn't reflect any payments from 3/26. It appears that everything from the weekend, which 3/26 was a Sunday, everything drops in the
Here's
bank
my
on
concern.
3/27.
The trier of fact discredited those screenshots.
Correct.
Two of them, they were discredited because they were not dated, for example. And the other one, the trial court doesn't really talk about, but, I think that we should look at it as it was just, no weight was given to it as a whole.
I think that's a fair reading that no weight was given to Defense Exhibit C. I see that I'm out of time, but I'll reserve.
If you
I
can-
think I have 3 minutes reserved.
Because what I'm going, it goes back to, going to, when you're looking at obtain, it looks like you're looking at those pieces of evidence. So how would you address my concern?
About the trial court discounting the evidence, well, on manifest weight review, the reason why the trial court discounted those is because seemingly it was unfamiliar with Chime Bank. The question is that a reasonable basis to discount that evidence? And I don't think that it is. It's also unreasonable when the A and B exhibits are bolstered by the Exhibit C, which the trial court seemingly ignored. So if we're going to take the trial court's findings for what they are, we know that it didn't address the Defense Exhibit C, and that would be a basis for reversal. The evidence before the court was not considered. Here's clear evidence of payment. And I think it would be a manifest miscarriage of justice if that was not considered by this court, the fact that there is evidence of payment the trial court below seemingly ignored.
Thank you for responding to that.
Morning, Your Honors.
Good morning.
Counsel. I too would like to start by addressing sort of the questions that the court raised in its recent entry regarding what would be discussed here today at oral argument. I'm going to start with the fines and costs. The state's position here is that Mr. Henderson has not paid fines and costs, and he never will have to pay fines and costs. To reach that conclusion, I've perused the judge's sheet, the clerk of courts, the transcripts, and the entry terminating probation. And in the transcripts on page 109 and 110, it clearly indicates that the court's intention was for defendant to pay, Mr. Henderson to pay $70 in restitution, and then it was going to remit costs and fees. Now, we get to sentencing, and this is on page 116 of the transcript. When the court actually imposed its sentence, when there was the back and forth between seeking a stay and wanting to appeal, and the Judge Russell said, I have to impose a sentence before I can give you a stay. When she actually imposed the sentence, she actually ordered that the restitution would be paid first. When she imposed $150 in fines, the costs, the 180 suspended days, the judge's sheet, as well as her pronouncement in open court, clearly say that the first thing that needs to be paid is the restitution. Everything is to be paid through probation. Now, if you get to trial docket 21, that's the entry terminating probation, seems to reflect that same conversation that Judge Russell had communicated to probation. Once he pays that $70, he is terminated from probation. And that is clearly what happened here. And that gets to my bigger point, which is that this appeal is moot. So what happened here, if we look at the timeline, Mr. Henderson was obviously given the sentence in open court. His counsel sought a stay of execution of that sentence. Judge Russell gave him the stay, conditioned on an OR bond with EMD and a stay-away order from the Jewelry Palace. At some point, Mr. Henderson went over to probation and paid that $70 in restitution, even though he didn't have to because it was stayed, and then he was terminated from probation. So he served his sentence voluntarily.
But I'm really struggling to see, and I was following along with what you're saying. I was looking at the documents as you described them.
Yeah.
But even on the entry terminating community control, it still says fines, costs, and fees. There's nowhere on here that says that that has been excused or waived or remitted or anything else.
I would suggest that the termination of probation, coupled with the judge's intent to waive costs and fees upon termination of payment of restitution, is pretty indicative that that probation was terminated. There's nothing on the docket, for instance, that says refer to collections or anything like that. This is divorce the record, but if you look at court clerk, it says no fines or monies owed. Clearly appears to me that he is not paid fines and costs and never will have to. This is for all intents and purposes over. That's our position on this. And just to get to the point that Ms. Nelson raised in her oral argument, regarding this analogy to a monetary bond, the state would suggest that it's not at all analogous. I mean, there was nothing to suggest that he couldn't go over to 800 Broadway and get an ankle monitor put on him. This is different than a monetary bond that he couldn't post. He wasn't incarcerated. He voluntarily paid the restitution, and his sentence is over. So that's kind of the state's position. I don't know.
Here's a concern I have with regard to your position. At the hearing, at the guilt or no guilt hearing, at that point, when the determination of guilt was made, the trial court stated that if the restitution was paid at the sentencing hearing, there wouldn't be anything further imposed.
Correct.
The restitution was not paid at the sentencing hearing. So what you're suggesting is somehow to read, despite that language, that something different did take place afterwards.
That she
Because
imposed a sentence of 180 days, 180 days.
Right, because because the restitution was not paid at the sentencing hearing, and so there was further monetary sanctions that were imposed at that time.
Yeah, I kind of get your point. Basically, what you're saying is that because he didn't pay the restitution, she imposed a greater sentence. That's what you're suggesting.
That's what she promised she would do.
Yeah, well, I mean, that was conditioned on him paying the restitution. It was like, let's just call this a day. I'm going to impose, and then but she also said, then you can appeal. I mean, I think if you look at the record, and maybe Judge Russell, I mean, it seems clear that she was willing to let Mr. Henderson appeal his conviction here. I could only speculate as to why she did what she did in imposing a greater sentence, but I think if you look at it in the greater context of this transcript where she says multiple times, I'm going to impose, $70 in restitution, no fines, no costs, then he can appeal my sentence. Maybe it was a misunderstanding on her part on the mootness doctrine. I don't think she was trying to put Mr. Henderson over a barrel.
Yeah, because what I also find interesting is what happened that led up to the entry that was terminating probation. Because it doesn't appear like there was a sense of formality that led up to that. And it does appear as if there might have been some ex parte communications that led up to that.
I mean, that's a fair reading of
And
the
it
fact.
also reads as if someone besides, the judge prepared the entry.
Well, that was prepared by probation. Now,
Okay.
Probation, I believe, typically prepares the entries terminating and then submits them when they terminate them. It's different than in common pleas where the judge signs the entry terminating probation. I don't think there's any irregularity necessarily with the entry. I think your suggestion that there was some sort of ex parte communication between the judge and probation, I mean, it's pretty clearly reflected in the entry that there was some kind of a conversation there.
And my point isn't the ex parte communications, because that's not,
Sure,
it's not even a battle that's worth fighting at this
Right,
point,
right,
okay?
right.
It's more about, it just appears as if you're asking us to look at an oversight and to recast that oversight.
Could you elaborate on that, please? I'm not sure I follow you here.
Okay, so it appears as if there might have been an oversight with regard to the monetary terms of the sentence at the time that the probation was terminated.
Okay.
And you're asking us to recast that into something different and to then
Yeah.
overlook the pronouncement that was made at the sentencing hearing.
Are we now talking about 150 and costs or versus 150 in costs, or are we talking about waiver of fines and costs?
Well, I think it's regardless of whether it's 150 and costs or in costs,
So we're
there's a
talking about-
monetary sanction.
We're talking about waiver here. We're going back to waiver here.
Mm-hmm.
I'm looking at this record, I don't see where he has to pay fines and costs. I guess that's our position on this, that he's just no longer subject to these fines and costs. We don't see anything that would really be indicative of that.
So if it's not clear, if the record is not clear whether these fines and costs are still outstanding, what do we do?
I guess from our perspective, maybe what Judge Winkler suggested when Ms. Nelson was up here, that we remand it for clarification on whether those fines and costs are waived. I guess that would be my druthers here. I don't see any grounds for reversing on any of Mr. Henderson's other assignments of error if we want to get into that. So
Well, I mean, let's not talk about the merits
Sure,
right now,
sure.
but what, I mean, is there any case law saying that that's the remedy? Or is there case law saying that when it's not clear, it's not moot? Or do you
I'm not
have any
sure
authority
this-
on that?
I'm not sure if the situation has arisen. You may have to, I haven't seen any case law on that issue. Maybe I'm missing something here. I don't know. So, yeah, I mean, maybe a remand for clarification or, if it's not moot, then I guess we're getting into the merits, right?
Well, let's get into the merits.
Okay, let's do that. We'll start with sufficiency.
Let me ask you a question first, before
Sure.
you start. Under what section of 2913-02A, which subsection is the conviction?
I'm not sure that the complaint specifies that. I believe it's A1, probably theft without consent. I don't see anything on the set of facts that would indicate deception on anybody's part. Mr. Siddiqui might disagree with me relative to Mr. Henderson's chime app. I don't know. So, I mean, the theft elements obviously are purpose to deprive another of property by obtaining control over it without consent here. So I guess we're probably talking about, I know you talked with Ms. Nelson about whether there was a purpose to deprive as well as consent on Mr. Siddiqui's part. I think Mr. Siddiqui's consent, to the extent that it existed, was a function of sort of Officer Quinn intervening, and it was at most conditional upon receiving payment. Now, Mr. Siddiqui came into court and he testified that he never received payment, and he, presented state's exhibits, I believe 2, 3, 4, and 5, which were receipts, 2 receipts showing decline, bank statements showing no payment posted on March 26th or 27th, and he claimed that he never got that money. So I think that probably, at least from a sufficiency standpoint, would suggest that we have met all of the evidence. Obviously, you would have to get into
Here's a
yes.
concern I have with that position. The way that this case was charged, it was charged under obtain, was it not? Not under exert control.
Obtain or exert control is the language.
What's
of
in the,
statute.
what's the charging document say?
Off the top of my head, I couldn't tell you that. I'm going to guess that I'm going to have to take it on your word that it says obtain.
And did the state ever move to make a motion at any point during the proceedings to amend that?
No, but he did obtain property. He obtained it from Mr. Siddiqui. He walked out the door of the jewelry, well, I guess not a door, walked away from the jewelry palace kiosk with the jewelry, so he obtained it.
Right, but it would be obtained without consent.
Right. And at some point, I think when Mr. Siddiqui, there was this conversation between Mr. Henderson, Mr. Siddiqui, and Officer Quinn, basically to the effect of, well, he was trying to keep the peace. Well, take the jewelry with you today, give him your information, and if he doesn't get his money, come back and pay it. And then Mr. Siddiqui's position at some point, when he didn't get his money within a couple days, or as he claimed, there was no longer consent for that to happen. And
Right,
he
but
told-
the state never moved to amend as exert control, which
I'm not sure
would then
I-
fall into the
I'm not
fact
sure I
pattern
follow the
that you're.
distinction here. I
Well,
apologize.
at the time that it was obtained, it was with consent.
Okay.
And if your position is at some point the consent was no longer there, or there was an issue, then my question is, should have the state moved to amend?
No,
to
I don't think it changes anything. There was sort of this, I think probably begrudging conditional consent at the time that this transaction occurred on Mr. Siddiqui's part to give him the jewelry, but that was conditioned on him getting paid, and he came into court and said he didn't get paid. So at some point when the charges were filed, there was no consent. So that would be our position on that. So yeah, I believe the state has clearly met all of the elements of the offense here. And if we want to talk about weight, I think what you said during your colloquy with Ms. Nelson about weight of the evidence, what Mr. Henderson is asking you to do is to interpret this evidence, which was ambiguous. The trial court was in a better position to evaluate the credibility of the witnesses, obviously, as well as the exhibit. So we would certainly agree with you, Judge Zayas, that it would be inappropriate to do what they're asking here and to really do a deep dive into the evidence and try and interpret it. So unless the court has any additional questions, I'm done.
Okay, thank you. Ms. Nelson, you have about 2.5 minutes.
Just briefly, I wanted to clarify something about the PNC records for purposes of manifest weight. There are no entries in that document from 326. There are 2 entries on 327. Both are in amounts greater than $200. So to the extent that the state is representing that there's no line item for $140, clearly he made over $140 in that weekend, and there's nothing to disprove Mr. Henderson's evidence, which shows that he did pay $140, and it could be absorbed within that $200 deposit.
So that was on a Sunday, correct?
Correct, 326 is
And,
Sunday.
and if I remember correctly, if you look at that statement, there weren't any charges on Sundays.
Correct. Throughout the entire PNC records, you will not find an entry from the weekend, which is consistent with most banking. I'm not a banking expert, but reasonable
Was
jurors would.
was there also testimony that was gotten from the vendor with regard to that point, that there were not transactions that would have been processed over the weekend? Or was it just the statements themselves that reflected that?
I'm not sure if that comes directly from the shop owner, but in looking at the exhibits, you can, it's clear for any trier of fact would be able to review that record and know, like, there's clearly no line item from 326. And there's 2 on 327, and when you go through a calendar, you can see that there are 2 entries on every Monday. So just by looking at the evidence, I can't remember exactly if that was testified to by
That's
the shop
okay.
owner. I cited A1A in my brief, the consent statute. I believe the state did as well. So I think there's no dispute here as to what subsection he was charged under. I'm not infallible to error, but I believe that everyone kind of agrees that that's what was pursued under this case.
And it's your recollection that the state never moved,
Correct, yeah,
never made a motion?
correct.
Okay.
Ms. Nelson, have you found any authority saying that the state has to prove that there was a lack of consent at the time that that the product or the services were taken? Did my question make sense?
Yes, it does.
Okay.
Because I know from within our office, we have argued consent issues before in the context
Mm-hmm.
of theft. And I'm just struggling to remember the specific facts of those cases because they weren't always mine. But I do know that that is a question at the time, I think, of when the property is taken. That it does arise under those circumstances. When the property leaves the owner's control, under
So-
what circumstances did it depart and go with the person who is now accused of theft? That's what I would submit.
Okay. Your time is up
Yep.
if you want to wrap up.
Respectfully, we'd ask this court to reverse and discharge Mr. Henderson from the charge of theft.
Okay, thank you. This case has now been submitted, and we will issue a timely decision. Our next case up is State v. White. Ms. Nelson, if you want to take a minute to get your stuff together for this next case, that's fine. Whenever you're ready. Would you like to reserve 3 minutes again?
Yes, please,
Okay.
thank you. Good morning again, and may it please the court. Good morning, Mr. Cummings. This morning, I intend to focus on the first and second assignments of error raised in my brief, the prosecutorial misconduct and speedy trial claims. And with the court's permission, I'd actually like to address them in reverse, starting with the statutory speedy trial claim. We're asking this court to reverse and find that David was not brought to trial within the statutory speedy trial limits, and that his charges be dismissed for untimely prosecution. I'm going to be using the 90-day threshold. He was incarcerated during this time, so he's subject to triple count within that 90 days. Just for clarification, I'm going to use that metric. So the law advises that speedy trial, the statute, is to be strictly construed against the state. And with that backdrop, I'd like to address two issues that I think are important to the speedy trial analysis in this case. The first is, what is reasonable time for tolling when it comes to tolling time on defendant's own motions? In this case, it's clear that there were two motions that were filed during a time where defendant had clearly waived speedy trial time. One was filed in February of 2022, and the other was filed in June of 2022.
I want to focus in on that for just a second. So in the brief, it's argued that under the rules of superintendents, court should rule on motions within 120 days. That's not necessarily what a court should, it shouldn't be a strict, that's what time is, but it was argued that 120 days is the guideline, correct?
Yes.
Okay, so 120 days from June 9th is October 7th.
Correct.
Okay, so what I would like is for you to explain how, I mean, if we're looking at October 7th, a lot of the time that you're claiming should be charged to the state wouldn't be.
I've two responses. 120 days is sort of a benchmark, and that October 7th date only relates to the motion to suppress, the last of the two filing. We still have the motion in limine to consider, which was filed well before that, which the trial court doesn't even mention in its entries continuing the case for purposes of the motion. Now, there are two issues about continuing the case to hear the motion to suppress. The time is one of them, but also the reason why it wasn't heard any earlier than when it was heard. And there's not a clear, reasonable basis for continuing the case beyond that October 7th date, which I think brings us back to, maybe it could have been reasonably heard well before that 120-day deadline. For instance, on October 15th, when the parties start appearing in court, where all these continuances are being contested, it's just there's no continuance for the purpose of the state needing to respond to the motion, to prepare for the motion. there's no continuance for the purpose of the state needing to do anything in relation to the motion. So why couldn't it have been heard much earlier? We're dealing with a total of 65 days, I believe, between the two substantive continuances, the one from August 15th to September 15th, and then from September 15th to October 30th. So yes, that October 7th deadline falls within that range. But the second of the two, the 35-day continuance, I think I have the most problem with, because we're continuing it all the way out to October 20th. Excuse me, I think I said October 30th, but it was October 20th. We're continuing it well out beyond that with no justification as to why the state needed 65 days in total. Yeah, we have to account for the family emergency notification, but there's no, from the August 15th entry. But other than that, it just seems the court, as a matter of course, is giving the state an additional 30 days. Not because the defendant wasn't prepared to go on the motion, but because the state couldn't be heard on the motion for whatever unexplained reason. So that goes to reasonableness.
The trial court can grant a continuance and charge it to the defendant if there is a reasonable justification. So are you arguing that the family emergency wasn't?
Well, I'm not saying a family emergency is not a reasonable basis to continue a case and not charge the time against the state. But we have to view that reason in the context of all of the dates that were continued, which is a total, in my view, 65 days between the two entries that I'm discussing, the one from August 15th and the one from September 15th. And between, really what we have to ask is 65 days reasonable to hear the motion to address the family emergency? Granted, the family emergency came up in the context of a 30-day extension, but we're dealing with much more time with that in the context of hearing the motion. So it's a couple of different issues at play. And I think total time was unreasonable, given the benchmark of 120 days, and that some of that time most definitely needs to be counted against the state.
Did counsel ever suggest to the judge that maybe it's a good time to schedule this motion to suppress, or the motion in limine? And what I'm getting at is, my understanding is that the search was pursuant to a search warrant. So isn't it the burden of your client to show that there's I know there are other issues involved, but there was a search warrant. So isn't it your client's burden to go forward with the evidence when there is in fact a search warrant? They want to suppress something obtained pursuant to the search warrant. So I guess the question is, why didn't the counsel ask the judge to set it?
Interesting question. So these continuances are not heard on the record. They're just entered by entry. We know from the motion hearing and the motion to dismiss
But the attorney
itself.
would be present to sign the entry, right? The
Correct.
attorney was there.
Correct, and they
knew that it was
note-
being continued and knew that there were two motions pending.
Correct, and they note specifically in the entry, defendant does not waive time, defendant does not waive time.
Okay.
So there is some conversation happening. The defendant is not agreeing necessarily to this continuance, and we know from the motion, and I believe the motion to dismiss hearing, that the defendant represented to the court that it stood ready to be heard on its motion at every single one of these continuances. So we know from the record.
It seems that they would mention that to the judge so the judge could hear it. You understand what I'm saying?
Sure, but
It's like
perhaps-
it's your motion.
Yeah, perhaps that they did, and that wasn't. The
It's
court
just not
speaks-
on the record.
Well, the court speaks through its journals, so we have to look at the reasoning supplied by the trial court in this case. And if there was some defense wasn't ready to be heard on the motion, then the onus was on the trial court to document that in its entry. It didn't, and speedy trial time gets construed strictly against the state, so it would behoove the trial court to make that notation in the record, but it didn't, and it explicitly noted the defendant did not waive time.
Okay.
So between those two, that's a substantial chunk of time that I think somewhere in that gets construed against the state.
And what time, and what would you suggest that that would be?
At
Because,
minimum,
these are calculations that sometimes one day makes a difference.
correct. I think at minimum, the 35-day continuance absolutely needs to get counted against the state. Even if this court decides that the 30 days from the first continuance, August 15th to September 15th, was reasonable because of the family emergency assertion, the subsequent one I don't believe was reasonable under the circumstances. Because I think the only assertion by the court in that case was just enlarged time pursuant to subsection H of the speedy trial statute, which again, we don't have any indication that the defendant needed time. Clearly, the prosecutor needed more time to address a motion that was filed back in June. There's no representation that they needed to file a response. They didn't file a response. there's no indication as to why that amount of time was necessary for the state to be heard on this motion.
And that calculated to 35 days to your best recollection?
From September 15th to October 20th, I believe is the time frame that I'm talking about.
Okay.
So that would, I think it's counted in our favor at minimum. I would like both, but I understand that the family emergency exception creates a little bit of a nuance there. And I'm not trying to say under any circumstances would family emergency not be a reasonable, but when you consider the total amount of time that was continued, we have to take that into account. Lastly, on this assignment of error, I'd like to address the ambiguity in the September 15th entry, because it is selected at the request of the state and the defendant. But the defendant writes in the entry, defendant does not waive time. And the state's correct, you can't have it both ways. The defense can't not waive time and also ask for a continuance, but because the statute gets construed strictly against the state and ambiguities are generally construed in the defendant's favor, that notation I don't think is something that should be held against the defendant in terms of the speedy trial calculus.
Was that argued below? That there was an error to that entry? Because that's what you're basically saying, there was something erroneous about that entry.
It was something that was raised in the state's brief that I replied to, is how I remember.
But with regard to before the trial court, was any of this?
How to construe this entry? No, I mean, the defendant's representations at the motion to suppress hearing was that they did not waive time. They did not waive time, and they maintained that. So, no, it wasn't specifically addressed, that check mark. It's my understanding that in our common pleas courts that a lot of these entries are prepared and not necessarily reviewed in advance of being signed. I don't know if that was the circumstances of this case, but it's a really important question, this ambiguity situation, for everybody to be on notice as to how to make these speedy trial records clear, which is why I wanted to bring it to the court's attention, because I don't think that it should be construed against the defendant under any circumstances because of the rule of lenity theme that I'm going with. The second assignment of error would certainly be dispositive of the case, but if this court is not inclined to reverse on speedy trial grounds, we'd ask that it does consider reverse on the prosecutorial misconduct claim in the first assignment of error. In this case, the misconduct took place during the state's rebuttal closing. It introduced a fact that was not testified to at trial, and this was not a simple misstatement of the evidence. It was a step too far in actually inviting the jury to consider a fact that was not testified to at trial. Why is this significant? Well, the state introduced 5 phone calls from the Justice Center, and they offered to the jury that Mr. White was a party to these calls. The testimony wasn't exactly a slam dunk with the detective who testified to these calls. There was some contention over whether or not his representation over who David was as a speaker was inconsistent with the listening aid that the jury was allowed to follow along with. So the jury's already sort of on notice that his representation of the call might not be as credible as the state claims. Then you enter Defendant Exhibit 56, which is Mr. White's cell phone records. And they represent before the jury during their closing arguments that the phone number that was testified to at trial would not be found in the records on the dates corresponding to the calls that the state entered. That's a significant omission by the state. And
Ms. Nelson, let's, hypothetically, if we agreed with you that it was improper for the prosecutor to state that 866 number during closing, there's still testimony that in the Securus system, 5 different calls to Mr. White's established phone number popped up. And was there testimony about the dates and times of these calls?
yes, during the detective's testimony, it's mentioned what date and time of the phone call, but not in the Securus records that were submitted. It was just the testimony.
Okay, so there is still testimony that calls were made from the jail to Mr. White, correct? And that's not disputed, that the Securus system showed that, correct?
Yes, it is disputed, however, when you enter Mr. White's phone records. It creates a conflict in the evidence is what I'm getting at. To the extent that the jury could accept the evidence that you just laid out, which is consistent with the record, it's now confronted with conflicting information that the state did not account for during its case in chief.
Didn't his phone records indicate those 5 calls? To me, it doesn't matter what the phone number was. They say, hey, here's Mr. Cummings' phone number, see how many calls came out of the Justice Center to that number. And I thought his records reflected those 5 calls. It just had a different phone number. Does that make sense? Do you understand what I'm saying?
Yes, I do.
All right.
If I could address the judge's question, then I'll
Yeah.
wrap up for my rebuttal. It's more significant in this case that the state's witness testified to a specific outbound number, and that number is indeed not represented in Mr. White's phone records on the dates and times of the alleged phone calls. Now, why this matters is because of a conflict in the evidence.
Well,
Yes, the
doesn't the
jury,
jury resolve that then, if there's a conflict in the evidence?
I'm sorry?
Wouldn't the jury resolve that then?
Yes, I agree.
Okay.
It should have been for the jury to resolve based on the evidence before it, but that opportunity was deprived because of the prosecutor who inserted the 866 number during closing arguments. If that prosecutor had not mentioned that number, I agree that the jury could have just looked at the evidence and sort of deduced for itself whether or not they thought he got phone calls around the dates and times of the, but they're deprived of that opportunity because the state gave them the conclusion that it wanted them to reach. This is the number from the jail. This is the number you will see represented in the records, which was not testified to at trial. It was an egregious misstep, and we'd ask this court to reverse accordingly. Thank you.
Mr. Cummings? Good morning.
Let me just pick up with what the last discussion was here. I think the state, the calls were relevant in this case because the officer Fields recognized the defendant's voice on the calls. The content of the calls indicates his involvement in the murder. The timing of the calls and the context line up with the timeline of events. The particular number from where the call was placed was never important to the state. That is something that was brought up in cross-examination by the defense, and they asked the officer, hey, is this the number that's going to show up? And he says, well, yes, it is. I think so. I'm not really familiar. The state didn't elicit this because this was not important to the state's case. And I think to the extent that this exhibit was admitted into evidence, the prosecutor in closing had every right to address that, respond to the argument that the defense made based upon that exhibit, and it's not misconduct at all. The prosecutor is entitled to draw inferences from evidence in the record. This was evidence that the defense put in the record. The prosecutor certainly can draw an inference from that. The inference is, hey, there's probably a couple of different calls, numbers that can show up when somebody calls.
But in this case, it wasn't, putting together some evidence and making an inference during closing. This was bringing in a brand-new, in this case, phone number and showing it to the jury. It seems like two very different things.
Well, the state didn't bring in the phone number and show it to the jury. The defense did. The defense said, this is the number, and this contradicts the officer. And that was their point in doing this. The state never put this number out. The state did explain it. The state did put it in context and gave a reasonable explanation for why this occurred. That was in response to the argument made by the defendant. The prosecutor is certainly allowed to do that. It's no different than for the prosecutor to say, look, based upon Exhibit 56, it's reasonable to infer that there's more than one number that you can call out of from the Justice Center. That's just as appropriate as the defense saying that because the numbers didn't match what the officer said, it wasn't the defendant's voice on the phone calls. The defense just argued that straight up, and there's no evidence to support that. But the defense made that very direct statement of fact based on nothing in the record, and they said, well, he wasn't on the phone calls. That wasn't his voice. That's an inference the defense drew. That's appropriate, certainly in closing argument, but it's not based on any fact that was established in the record. The prosecutor and the defense are allowed to draw inferences from what is in the record and make their arguments accordingly, and that's all that occurred here. This was not misconduct at all, Your Honors. That's the state's position here on that issue. As far as the speedy trial goes, on the record itself, based upon the tolling provisions of the statute and the case law, which provide that time is tolled when the defendant files various motions, and then a family emergency or a prosecutor unavailability, these are legitimate reasons for tolling time. Based upon the case law and the statutory exceptions, the record supports the fact that Mr. White was brought to trial within time. if there was ever a concern about the reasonableness of a length of a delay, the defense should have asserted that somewhere during the process. It should have said, look, this is getting too long here. Let's make a record. Let's bring it up to the trial court at a time when the trial judge can correct the error, or at least make a record explaining why what is occurring is happening. The defense didn't do that. They just kept on, signing motions and continuances, and that's the way it usually works, and that's fine. The troublesome thing here, though, is aside from ambiguities, I'd say that there's clear evidence of gamesmanship. What I found troubling is the defense sometimes asks for a continuance and then writes down, I'm not waiving time, though. I mean, what's that? That shouldn't be countenanced. That's true gamesmanship, and I don't think that should be indulged. But to the extent that there's some issue about the reasonableness of a delay, it wasn't asserted by the defense. It wasn't brought up at a time when the parties could make a record about it. So based upon what this court has before it in the case law,
I just want to
think this-
clarify something you just said about the defense also writing down that it didn't waive time. Are you saying that these entries were presented to both sides, and both sides had an opportunity to write, fill in the blank, fill in the box, whatever?
Yes.
They were not electronically prepared by the bench?
I honestly don't know that. I know that the entries are prepared or checked by court staff or somebody, and then the defendant, counsel, and the prosecutor have to sign off on it. I think here, whoever marked at the request of the state and the defense, whoever marked that, presented it to both attorneys, and the defendant's counsel, I guess, deliberately wrote, "Don't waive time." And I think that clearly had to be affirmatively done by the defense counsel. That's not something that would have been generated by the court staff or something. So I think that's a troublesome indicator to me that the defense is trying to have it both ways, as counsel acknowledged. That's not good form. That's not the way things should work. So I think that's clear here. But unless there's some type of attempt to make a record, a request for an explanation about the reasonableness of a delay, this court has to presume the regularity of things. And I think that on this record, that Mr. White was clearly brought to trial within time. Unless this court has any specific questions, the state will rest on its
Let me
brief.
have just you address one thing. One of the arguments this morning is that, in essence, the entry should be strictly construed against the state. So, the idea that a continuance was sought by both sides, and yet the entry, the box or whatever it is, stating that the defense did not waive time. What's your position on the idea that that should be strictly construed, and thus the waiver, the not waive time is what governs that entry?
Well, I think that there is case law on that. I don't think that's ambiguity. I don't think that that's an ambiguous situation where you have to strictly construe it against the state. I think what it more directly shows is gamesmanship, and I think that's what's more troublesome. I don't think that's ambiguous. I think everybody looks at that entry and knows what's going on. I think that, somebody wants their cake and they want to eat it too, and I don't think that should be countenanced. So I don't think that's an ambiguous situation that requires strict construction against the state. I think really it should call the court's concern and attention to what the defense counsel was trying to do. But at any rate, if the defense counsel was concerned about the delays, it should have been asserted in a time when this could have been addressed by all the parties. And that wasn't done here. And so on the basis of what this court does have before it, I think it's clear that this man was brought to trial within time.
Thank you.
Thank you.
Thank you.
We have about 2.5 minutes.
Thank you. Just a quick point on the prosecutorial misconduct claim. To the extent that the state is representing that what was the outbound number, was not important to the state's case. It clearly was very important to the defendant's case, who was teeing up the testimony in support of its exhibit, Defense Exhibit 56, which was the only evidence that the defendant put on in this case. Now, the state was on notice of this. They represented to the trial court that they received this in discovery. So it was within their knowledge that the phone number that was testified to at trial would not be represented on the dates of the phone calls that they admitted to, or they admitted into evidence. As far as what could the state have said during closing arguments, well, they could have reminded the jury of the dates and times of the phone calls that were admitted into evidence and say, review those dates and times with respect to the records. They didn't. Again, they went one step too far, and it was an egregious misstep, as I said before. Why? Because it completely deprived defendant of a fair opportunity to have his records considered in light of the testimony that was presented at trial. This isn't just a case where we're disagreeing about the testimony. There was a cold exhibit, an unbiased third-party exhibit that was admitted into evidence that creates conflict with the state's evidence. That is important with respect to David being able to present his case in the way that he wants to. The state deprived him of an opportunity to have his case fairly considered by the jury by giving the jury the conclusion that the state wanted them to reach, and I think this is grounds for reversal for a new trial on prosecutorial misconduct. Just to clarify on the speedy trial, I know that I mentioned the 35 days. I just wanted to be clear to the court that I have a whole list of dates that should be charged to the state in my brief, and I don't want to abandon those dates. I calculated over 130, I think it was 139 total. I submit on the arguments that I presented before, but if there's any confusion as to what time I specifically think should be charged to the state, it's all outlined in my brief. If there are no further questions, we'd ask this court to reverse.
Thank you.
Thank you.
This case has now been submitted, and we will issue a timely decision. Okay, our final case to be heard today is State v. Smith. Ms. Berry, would you like to reserve any time?
3 minutes, please.
Thank you. Whenever you are ready.
Good morning, Your Honors. May it please the Court. Michelle Berry on behalf of Mr. Kent Smith, the appellant. This case is a very straightforward case about an excessive, disproportionate sentence that violates Ohio law and the state and the federal constitutions. So the bottom line is the excessiveness, the disproportionality, and the deliberate disregard for rehabilitation in the 79-year sentence that was given. But in the briefing, I framed this issue in 2 different ways. In terms of the judicial bias and the related due process concern, and then secondly, the actual violations of Ohio law and the state and federal constitutions. And I just want to briefly explain the framing in terms of the judicial bias, because I think it's very important for the court to keep in mind the background and the atmospherics that led to this excessive sentence, because it's clear in the record. There was atrocious and shameful ineffective assistance of trial counsel in this case. And it's unique in the aspect that many times when you have ineffective assistance happening at the trial court level, it's not so clear in the record. Like maybe some additional investigation needs to be done, and that certainly is the case here with the DNA testing that was never conducted. But what you do have in the record very clearly is a change in the court's attitude towards Mr. Smith. And there's this evolution that occurs that you can see in the transcript that's all at the hands of defense counsel vilifying Mr. Smith to the trial court to basically cover her tracks for not investigating the case, not pursuing DNA testing.
I want to ask something for clarity.
Yeah.
That took place before it was remanded for resentencing.
Yes, this was in the original case that went to trial.
Right.
So
how would that then be relevant as to the sentence that was rendered at resentencing?
well, it was the same judge, and it was very clear when it was remanded by this court. This court had reversed a couple of the counts on insufficient evidence. It was remanded back. The same judge got the case back, and it was very clear that he remembered the case quite well, was a bit hostile of the fact that some of the counts were reversed to begin with, and very much remembered Mr. Smith and made comments to that effect in the resentencing about how, you know, he wanted him to spend the rest of his life in prison. Gratuitous comments, you know, how he didn't expect him to be able to serve as post-release control because he would get out when he's 116. It relates back to this attitude of hostility that began when the case was initiated at the trial court level prior to the trial happening. And it was, it's evident because the court starts out very fair and impartial, as a court would. You know, the court even suggesting, let's continue the case so that this DNA testing can happen, to later, months later, after defense counsel sits for months and doesn't do anything, but's telling the court, I'm contacting the DNA expert every day and they're not calling me back. It's lies. The CEO of that DNA company, DDC, submits a letter later in Mr. Smith's behalf that's an exhibit to case C21, in this case's history, the appeal that's C210035. It's an exhibit to that where she explains, no, we weren't receiving calls, we weren't asked to pursue anything. And that hostility by the trial court is borne out in the record where he's later then saying, well, that the expert obviously didn't find anything helpful because they weren't responding to all your inquiries. And trial counsel I mean, I'll just be blatant, she lies and says, yep, they're not responding to me, I'm trying every day. And it's really, it's hard to read that and it's really shameful. And you can see the effects of that on the court. The in-chambers discussions basically become like an everybody versus Mr. Smith thing. And it impacted the situation. So then when it came to, that's the background of this ultimate, what was a 101-year sentence. It was later reduced to 79 years after this court's remand for resentencing. So what we have at this point is the 79-year sentence, which is obviously slightly better than 101 years, but in practical effect for Mr. Smith, still beyond his life expectancy. He was 41 at the time. I think he's 43 now. And what Ohio law requires is to look at certain factors when you are giving maximum consecutive sentences. These factors are proportionality.
I looked at your brief, and I am not seeing any citations at all to, hold on just a second, let me actually look up the statute to make sure I'm saying the right one, to 2929-14C4. I'm not seeing any citations to it. It seems like you're focusing on 11 and 12, but not on 14.
Well, first of all, 11 and 12 reference 14. So those are, 11 and 12 are kind of the umbrella. And if you notice in 11 and 12 and 13, they reference .14. And so that's encompassed within it. But that was something that we wanted to draw in the reply, figuring the state was going to raise the issue that the court satisfied the .14 factors, because that was the whole reason the case was remanded to begin with, is because this court had said the court didn't meet the 2929.14 factors, which is the court has to prove that if it's giving maximum consecutive sentences, that it's necessary to protect the public and punish the offender, that it's not disproportionate to the conduct in question, and that the one of two, the harm was either so great that a single sentence isn't going to rectify the harm that was done, the danger that is posed, or the offender's history requires such a sentence. And that was the entire reason the case was remanded. So, often it's a strategy on reply to make the argument in the case in chief, but then wait and see what the state's going to say, and then really hammer the point home in the reply. And knowing that the entire case is about that, I wanted to hammer home those points in the reply. But of course, it's raised at the outset through point 11, 12, and 13, where that statute is referenced. And of course, the entirety of the brief, the errors discuss proportionality and excessiveness. That's really the crux of the entire issue here. If you look at other cases throughout Hamilton County and other cases throughout Ohio, you won't find a situation where the facts are, and I don't want to minimize what happened here. These are all serious offenses that he's convicted of. But you won't find a situation where the egregiousness level is as low as it is and the sentence is as high. But what you will find are situations of attempted murder of police officers, sexual.
I'm going to go back to my earlier point. So your brief focused on 29, 29, 11, and 12. And under the Jones case, we are not permitted to independently weigh the evidence and substitute our judgment for the lower court under those statutes, correct?
Not under point 11 and point 12, but under 2953.08 G2, this court is permitted, if factors A or B are satisfied, this court is permitted to modify the sentence. And even if this court didn't find that those factors are met, which I'll explain in a moment why they are met, why they both are met, even though you only need to meet one, this court would be allowed to remand for a resentencing. But ultimately, I think the most appropriate thing here, because 2953.08 G2A and B are both satisfied, the most appropriate measure would be for this court to modify the sentence. Those factors are, like I said, it's very important to note that only one of those factors needs to be satisfied. And the factors are, is the sentence contrary to law? That's B. I'm going to start with that one first, but the A factor is it clearly and convincingly, is the sentence clearly and convincingly unsupported by the record? So in other words, in this case, because it was the 2929.14 factors that the court missed the first time and that he's making sure to recite in the resentencing, is there support for those factors in the record? Because it's undisputed, he reads the factors off. Yes, that's correct. He reads what the statute says, and he gets that into the record. But what 2953.08 G2A is asking is there support for those factors in the record? And there certainly is not, and I'll get into that. But the B factor, is the sentence otherwise contrary to law, is very simple to rectify. The 2929.11A requires the court, it's mandatory that the court consider the minimum restrictions necessary and consider rehabilitation. Those are mandatory. And it's very clear in the sentencing, he's doing exactly the opposite. He's purposefully giving the maximum consecutive sentences. He's purposefully not considering rehabilitation. So we have a sentence here that's clearly contrary to law for those reasons alone. But then when you turn to the A factor, it's just as bad. We meet that as well. And like I said, that standard is the sentence clearly and convincingly not supported, those factors, are they not supported by the record? And you look at what those factors are, and they require looking at the offender's background. Well, here in this case, the trial court even noted that Mr. Smith's background was quite minimal. He had a possession of marijuana and a carrying concealed weapon. He had never been to prison before. That's the extent of his criminal background. I think he had a juvenile receiving stolen property. That was the extent of his criminal record. He was not somebody who was a repeat violent offender like you would think would be receiving a lifetime sentence, essentially. That just simply wasn't the case. Another important factor in the 2929.14 is looking at the conduct in question, of course. There were many counts here, but only 3 of the counts alleged any sort of physical harm. And again, not to minimize, but on the scale of physical harm that trial courts see come before it and this appellate court sees come before it, this is on the minimal side. He held a gun to one victim's head. He's alleged.
Did he shoot a child?
He did, and that's obviously a horrendous fact. But I would like to point out it was an unintentional shooting. in the offender, as the offender was trying to try the door, basically, try to open the door and finding it locked and not opening, shot through the door and, of course, hit the person on the other side, which was a 14-year-old child, which is a terrible thing to happen, but important to note, unintentional. So that was obviously the worst instance of violence in one of the counts. The only other
If
allegation.
you want to reserve your time is up.
Okay, I will address the remainder in rebuttal. Thank you.
Thank you. Mr. Souter?
Good morning, Your Honor.
Good morning.
May it please the court. I'd like to begin with the strong presumption that the trial court is not biased. I think the instances of ineffective assistance of counsel that are cited in the brief and today at oral argument, if they occurred at all, there's no showing that it had any, it engendered any animosity on the part of the trial court or had any effect on the sentencing. The trial court had a thorough sentencing hearing, which clearly set forth the reasons for its for the sentences that imposed. And I think any comments, gratuitous comments that it made were just in response to this court's reversal of certain accounts, and they had nothing to do with animosity toward Mr. Smith himself. Judge Bach, I think you hit the nail on the head with the 11 and 12 factors cannot be reconsidered or reevaluated by this court under State v. Jones. And the factors that are set forth in 11 and 12 are essentially the same that are set forth in 2953-08, contrary to law or unsupported by the record. And this court, as the Supreme Court has said, has no jurisdiction to reweigh those factors. In terms of the sentence itself and proportionality, this court has held in State v. White that Gwen 5 no longer permits a consideration of the aggregate sentence that's given in connection with consecutive sentences. And I think that forecloses much of the argument that the appellate counsel raises today. And just the thought that this defendant was overcharged or over-sentenced is just not borne out by the record. This court, in the direct appeal of this case, here's the way it encapsulated the crime wave that the defendant perpetrated. This is from the state's opinion in State v. Smith. Defendant appellant Kent Smith committed a string of burglaries, robberies, and felonious assaults in December 2015. Many of the crimes were violent and caused serious harm to the victims, including a 14-year-old boy who was shot in the chest by Smith and a victim who suffered physical injuries and emotional distress after being assaulted and robbed by Smith twice in a 10-day period. I fail to see how anything. I fail to see anything inappropriate in this sentence, given those facts and the recognized seriousness of these offenses and the harm that was caused. I would just ask the court to affirm the judgment of the trial court. Unless there are questions, I have nothing to add.
Thank you. Ms. Berry, you have 3 minutes.
Just to start where Mr. Souter left off, again, not to minimize any of the harm caused by the offenses committed, but those were just 3 of 12 remaining counts, or 13 remaining counts. And maximum consecutive sentences were given on every single count. There was not physical harm alleged on every single count. And Ohio law requires that those 2929.14 factors be met in every instance that a consecutive sentence is given, and that a maximum sentence is given for the most egregious form of the offense. And we just simply don't have that here with, in my submission, any of the counts, but at a minimum, the remaining counts where no violence is alleged. So that's one factor to contend. And I would just like to briefly raise on the cruel and unusual punishment arguments. I think that the, not just the federal constitution, but the Ohio state constitution leaves some room to expand the principle in State v. Moore that outlaws an aggregate term exceeding the lifespan of offenses that were committed as a juvenile. Of course, that's not permissible under the federal or state constitutions. But I think that there's room to expand that to other situations, including this one, where it's, the definition of excessive given by the Supreme Court is makes no measurable contribution to acceptable goals of punishment. And other guidance that's given by the Supreme Court is punishment violates that cruel and unusual punishment clause if it's contrary to evolving standards of decency. And here in Ohio, there's clearly a trend away from maximum consecutive sentences. Of course, there's a presumption of concurrent sentences, but there's more and more a trend towards rehabilitative efforts. And again, that's a mandatory consideration under point 11. And so I think that all of those factors combined, we just have to look at the proportionality and excessiveness as a whole. And it's not explicitly overruled by Gwynn. That's a topic that's still being considered by the Ohio Supreme Court in Glover, which is taken up by the Ohio Supreme Court, which hasn't been decided yet. As of right now, that can be considered as a factor. The aggregate total can be considered. It doesn't have to be, but it can be when this court is operating under 2953.08 and G2, the possibility of modifying a sentence. So with that in mind, I'd just like the court to consider the totality and the overall disproportionality and excessiveness of the sentence exceeding his lifespan for these crimes that don't meet the most egregious form under any circumstances. Thank you. If there's no further questions.
Thank you. This case has now been submitted, and we will issue a timely decision. That concludes court for today. Thank you for coming, and have a great day.